So many familiar faces. It actually makes me ache to see some of your names and faces. I haven't seen you in so long. I'm Rory Barthel. I'm the president of our local New York City chapter of the Labor and Employment Relations Association. LERA is a group of management, labor, and representatives and advocates and neutrals working towards progress together in the field to advance a common understanding of the issues we confront. We have a program tonight on the recently passed Just Cause law in New York City. We have New York City Councilmember Brad Lander here, Paul Sonn from the National Employment Law Project, and Lisa Griffith, a management attorney from Littler. For tonight's program, we are offering CLE credit for New York. If you'd like that CLE credit, please put your email address in the chat and you will receive the CLE materials to be completed and returned to me. The chat should also be the repository for questions. We have a pretty high registration tonight, so we don't want to have a lot of people talking. So please make sure that you stay on mute. And if you do have questions or comments, enter them in the chat, and they'll be addressed at an appropriate time later on. With that, I'll hand this over to Bill Herbert, the secretary of LERA, who arranged for tonight's program. With one more word, tonight's program is being recorded, but for quality assurance purposes only. So, Bill.
Good evening, everyone. I'm a distinguished lecturer at Hunter College, as well as the New York City LERA chapter secretary. On behalf of the chapter, I want to thank National LERA Executive Director Emily Smith and Bernadette Thierman for their assistance with the registration for this meeting. Our meeting agenda is a discussion concerning New York City's new Wrongful Discharge of Fast Food Employees Act, as amended by local law number 1, granting fast food workers in New York City just cause protections and protections against layoffs. They were signed into law by Mayor de Blasio earlier this year on January 5th. Historically, New York has been a frequent laboratory for innovations in workplace rights, dating back to the days of Al Smith, Franklin Roosevelt, Francis Perkins, and Robert Wagner Sr. and Jr. But the legal concept of just cause is not new. It was first codified into American labor law by President William McKinley during the first Gilded Age, at about the same time that the common law at-will doctrine became predominant. In the private sector, just cause protections already exist in other jurisdictions, including Montana, Puerto Rico, the U.S. Virgin Islands, and in Philadelphia. And of course, just cause is most common under public sector due process statutes, such as Education Law 3020A for teachers, and in collective bargaining agreements and individual employment contracts. In the chat, I'll be placing shortly a link to the CLE materials, including links to New York City laws under discussion, along with other materials relating to just cause, as well as the complete bios of our speakers. So let me now introduce the panelists. Brad Lander is a member of the New York City Council, representing the 39th District in Brooklyn. Brad serves as the council's deputy leader for policy and co-founder of the council's Progressive Caucus. Brad was one of the primary architects of the Just Cause legislation. He's been a central figure on the City Council in developing New York City workplace legislation, including laws regulating the setting of work schedules for fast food workers and providing wage payment protections for freelancers in New York City. Our second speaker is going to be Paul Sonn, who is the State Policy Program Director at the National Employment Law Project, NELP. He directs NELP's state and local policy program, helping advocate for stronger worker rights and economic justice policies across a range of issue areas. Our third speaker will be Lisa Griffith. She's a partner with the law firm of Littler Mendelson. She represents and counsels companies in all areas of employment law. Her practice focuses mainly on employment litigation, and she works with both large and small companies, including those in the restaurant industry. Now, for tonight, we're going to ask that questions or comments be made using the chat function at the bottom of your screen. Please keep your questions or comments short and make sure that if you indicate who you want the question to be directed to. At this time, we also encourage you to please mute yourself to avoid extraneous noise during the meeting today. So we're going to begin with Councilmember Lander because he will have to leave early due to another commitment. We've asked him to provide us with a background and context of the legislation And after his remarks, we will allow him to respond to questions and comments from the audience submitted through the chat function. After Councilman Lander presents, then we'll turn it over to Paul, who'll discuss the substantive provisions of the law and the implications for fast food workers, followed by Lisa, who will discuss the employer's perspectives on law as well as the procedures for enforcement of the law. Assisting us tonight is Joseph Vandenel, who's a PhD candidate at CUNY Graduate Center. He'll be assisting with the questions and answers. So Councilman Lander, you have the floor.
Thank you so much, Bill. It's really an honor to be here with you. This is my first LERA event, and I'm glad to be doing it. I don't go back to the days of Bill McKinley or Al Smith, although I will add a historic note, right, that Thursday is the 110th anniversary of the Triangle Fire, which also prompted a lot of, labor rights and occupational health and safety legislation and protection. But I have now for about the past decade been working with both different sets of workers and over time with what has now become the Office of Labor and Policy Standards at the Department of Consumer and Worker Protection in New York City to think about what are the ways that New York City can show up for its workers and provide appropriate, grounded legal protections that New York City's workers need. So the first campaign of that type when I was just coming into the city council was the legislation to provide paid sick leave for New York City workers who did not have a legal right to it. And since then, New York State has passed similar legislation and many other municipalities and states around the country. That was the first municipal worker protection that the Office of Labor and Policy Standards and at what was then Department of Consumer Affairs, now Department of Consumer and Worker Protection, was set up to provide remedies for. And then I've done a number of other pieces of that work along the way. Bill mentioned the Freelance Isn't Free Act, which provides that hiring parties have to pay their freelancers in a timely way and provide them a written contract, and has helped hundreds of freelancers secure millions of dollars that they had been stiffed out of. Similar work with fast food workers, with Uber and Lyft drivers. That actually is regulated through the Taxi and Limousine Commission, not through the Department of Consumer and Worker Protection, but we became the first city in the country to provide a minimum rate of pay for Uber and Lyft drivers. But the deepest bunch of work that I have had the chance to do has been with fast food workers. It happened that I was at some of those early Fight for 15 actions when fast food workers were demanding a $15 minimum wage, and that ultimately was won at the state level, not at the city level. We're preempted from doing a minimum wage of that type, but they won a $15 minimum wage first for fast food workers and then just for all workers in New York State. And out of that relationship with them, I started working with them on a lot of the issues and challenges that were facing fast food workers in New York. As Bill mentioned, the first of the issues that we worked on together was around their lack of stable schedules. Many of them didn't get any advance notice of their schedules, had to require to be on call, so it wasn't possible to balance childcare or school, had to close late at night and open early in the morning, didn't have an opportunity to become full-time even if they wanted to. They were kept in permanent part-time jobs. So New York City's Fair Workweek Law was the first one at the city level that focused specifically on the fast food sector and requires fast food employers to provide 2 weeks advance notice of schedules, it bans on call scheduling, and provides a path where available shifts have to be offered to existing employees before new employees can be hired, so that if workers want a pathway to a full-time job, they have it over time as shifts become available. And of course, there's other workers leave. So it was really through that that I worked a lot. Once that was in place, because, at that time, they now had 725 before when we started, 2 weeks advance notice of their schedules and pathway to full-time work, and paid sick leave. Those jobs have become just a lot more stable. It is possible to support a family. And so what then a number of the workers said is, now we would like to be able to keep them. And quite a few of them, really a surprisingly high number, reported that they would either lose hours, have shifts canceled, or just have the number of hours a week that they're working or in some cases be fired, really on the whim of their boss. And I think, in a lot of cases, what was behind it might have been something they expected would be actionable. That might have been a woman who, refused to flirt with her boss, and maybe she had a sexual harassment claim, but she didn't really know she hadn't filed it. And all of a sudden she got fired or lost hours. There were just a whole range of things where you'd be told, well, even though you had never gotten any feedback before, you didn't smile enough at your customers, or your nails are too long, or you weren't given any reason at all. Because of course, if you're at will, you don't have to be given a reason. And, I just talked to worker after worker after worker who had a story of either being fired or having hours reduced as a result. And some of them even said to me, look, Councilmember, when these jobs were just paying $7.25 an hour, and I didn't see a path to it full time. I still didn't like it, but it didn't feel like important to be able to hold on to. Now that it pays $15, that I can get a full-time job, that I have a stable schedule, I want to be treated with some respect. I want to know that I can, stay in that job and get feedback to improve my my work if it needs improvement, and have job stability that workers have. And it was around the same time that I read in the New York Times an op-ed, I don't know, about 2.5 years ago by Sean Richman and Paul will remember who the co-author was. So that spoke to this broader issue, which obviously I've been an employer, and so I was familiar with the dynamics of both at-will employment and just cause protections, but it hadn't sort of occurred to me that it might make sense to do something legislatively. So I reached out to those fast food workers who by then were organized largely through SEIU 32BJ, a labor union that they are not organized with through NLRB, but that provides support for their meetings and thinking about different issues. And we sat down together and looked at what this might mean. And lo and behold, when we described what just cause protections were, the workers felt like, well, of course, that would make sense. We ought to get feedback if we need to improve. If someone does something for which there could be immediate termination, someone, does something to a coworker, obviously there are grounds for immediate termination, but those policies just ought to be spelled out and they ought to be followed fairly. And you shouldn't be able to be fired on a whim without any reason or notice. And we realized that there was no reason built based on the laws that New York City had passed previously that we couldn't do that. So that's what led us to develop this legislation. It went through a lot of iterations. There were some amendments. We sat down with fast food employers as well. I guess I'm going to stop there because Paul's going to go into the details of the law. But I just wanted to provide a little background on sort of the history and the politics. I will say, it passed the council overwhelmingly. We had a hearing at which a lot of workers spoke up in favor. There was a panel of fast food and restaurant employers who spoke against the bills, for a range of reasons that you might imagine. And there's a couple of Republicans and a couple of conservative Democrats in the council, but it was passed by a much more than 2/3 of the council, much more than a veto-proof majority. The mayor signed it into law. And now the Department of Consumer and Worker Protection is standing it up. So let me stop there. Again, I think for people really interested in the legal details, Paul is going to go through them. But if folks have questions about the history or the politics or what we were trying to do, our legislative intent, I am glad to talk about it.
Councilmember, how much time do you have? I know you have to leave early, so I want to be sure.
Yeah, I can stay till 6:40.
Okay, good. So if anyone has questions for the council member and you want to add it to the chat, we can ask the question now for him. But I will start with a quick question for you, which is, in light of this legislation, what do you think is going to be what do you think of the possibility of this concept of local or state legislation taking hold around the country, either in Albany or elsewhere?
Yeah, I mean, I'll give an interesting example. Around the same time that we were finalizing the just cause protections for fast food workers, journalists at The New Yorker were organizing for them through their union. And, they were going to have the New Yorker Festival. And then I guess Elizabeth Warren and AOC said, we're not going to be able to participate unless the New Yorker steps up. And it led to this conversation in which we had the beginnings of a dialogue between some of those New Yorker writers and some fast food workers. And I think it definitely begs a question, if New Yorker journalists need fast food protections and fast food workers need just cause protections, who doesn't need just cause protections? And that dialogue is now taking place. Actually, we weren't the first in the country to do it. Even in this more recent round, Philadelphia covers parking lot attendants. I don't know exactly why they started there. I started with fast food workers because those were the workers who reached out to me and described these problems in their industry. But yeah, so Paul will talk a little more. There's folks considering legislation in Illinois. And I'll say here, I'm interested in the possibility, we want to see how it works and how it gets stood up. But I think there's also some thinking in New York City, that there's a whole range of other workers who this is a very reasonable protection and something that they would have the right to expect.
So one of the questions which I would ask that both the council member and Paul respond to, it comes from Evan, who's asked whether the law restricts laying off of workers for lack of work, and how does that play into the legislative history of the just cause provision? Do you want to start?
So I can answer this on the sort of just the legislative history, and Paul can go there. So there's two laws that passed simultaneously that really do one thing together. Councilmember Adrian Adams was the sponsor of the one relating to layoffs, and I was the sponsor of the one relating specifically to just cause terminations. What we realized was, you need some way of making sure that, if you want to prevent unfair, causeless firings, you don't just leave a pathway where you could do an unfair, causeless layoff and be able to do the same thing by calling it a layoff that we're trying to prevent you from being able to do through termination. So the bill requires that layoffs for, if an employer has to do layoffs for economic necessity, of course, they'll have to do that, but they have to be made by seniority within the relevant job category. And that is the protection.
And I should mention that in the link that I posted just before in chat, you can download from that link both statutes just referenced. One was local law number 2, and one was the local law number 1, and they intersect with local law number 1 amending local law number 2. Paul, do you want to speak directly to the issue of layoffs, or do you want to proceed with discussing the just cause standard first?
Sure. I mean, I can jump in. I mean, I was going to maybe do the just cause standard and then jump into the layoffs.
Paul, before you dive in, I have a question asked to me directly by direct message that let me just go ahead and answer, from Jim Billick, who asks how we landed on 30 locations as a floor for covered employers. And that's a pretty straightforward answer. We took the definition of fast food employers that had been developed by the state wage board when they implemented the $15 minimum wage for fast food employers to begin with. I am not 100% sure what was behind their selecting that. Paul may know more than I do because he was involved in that campaign as well. But once there was a standard state definition for fast food employer, it seemed to us very sensible just to use that. And so we took the definition from the wage board and used it both for the Fair Workweek Law and for the Just Cause Law.
I think it was just an effort to define a universe of sort of the large chains, that have a lot of economic power, and that, that reasonably can be expected to in that case to pay, what was initially, it was the first $15 minimum wage in the country, but that are, not mom and pop small businesses.
So Paul, do you want to start talking about the definition of just cause under the statute?
Sure. And well, so jumping in, and be happy also later touch on some more of the context. Actually, just very briefly to say, it's really so interesting that this is really the first conversation around reining in at-will employment in about 30 years that we've seen in the U.S. And polls consistently show that U.S. workers are surprised to learn that they can be fired without a good reason or advance notice and left without a paycheck and bills coming due. And which is really, the U.S. is really an outlier internationally in not having protections against arbitrary firings. And as many of you know, back in the 1990s, many states had started to chip away at will, and there was a Uniform Law Commission proposal of a model state just cause law that led to a lot of serious conversation. But that era passed, and only a handful of U.S. jurisdictions adopted just cause. So this is this new wave of this new conversation sparked by this campaign, by the Philadelphia law Brad mentioned, and others is really we think long overdue. And it's interesting, and this first ordinance took place in the context of the multi-billion-dollar fast food industry, a sector that's been booming, and especially even during the pandemic, the top 8 fast food chains are seeing their stock increase more than 20% and are really expanding their market share. So it's really, we think, a really timely issue. And actually, like so many labor issues, the pandemic is making the problem of precarious work even more urgent. Worker whistleblowers this past year have been threatened or fired for sounding the alarm about unsafe workplaces, highlighting the need for stronger protections against unfair firings. So we really think this legislation is timely, and we expect to see more cities and states beginning to follow New York's lead. So I'll jump into the two key sections of the law: the just cause protection against firings, and then the layoff provision. So starting with the just cause provision, at its core, it really requires employers to take the steps that responsible employers already follow, which is giving employees fair notice of any job performance problems and a chance to address them with feedback and coaching before they're let go. The core provision, which is 1272A in the first ordinance, it prohibits fast food employers from discharging workers without just cause once they've completed any probationary period, which can be up to 30 days. There's then in turn a definition of just cause, which is defined as failure to either satisfactorily perform job duties or misconduct that it's demonstrably and materially harmful to the employer's business interests. And then another key concept it defines is progressive discipline, which many of you are familiar with from other contexts, and is the process that employers are required to use to comply with just cause. And it defines progressive discipline as a disciplinary system that provides for a graduated range of reasonable responses to an employee's failure to satisfactorily perform their job duties, with the disciplinary measures ranging from mild to severe, depending on the frequency and the degree of the failure. So those are some of the key concepts. And then it requires that just cause be used be satisfied for discharges in all except really 3 circumstances. The first, there's a carve out for egregious employee misconduct, which can justify immediate termination. There's a similar carve out for employees' egregious failure to perform their job duties, some sort of very, very serious failure. Or number 3 is the second part of the bill, like the exception for economic layoffs, which have a different standard but don't require showing of just cause. And then in terms of procedure for making these showings, those there in 1272B of the law, it specifies a range of factors that go into determining whether discharge meets the criteria for just cause. And there are several factors there. One, the employee needs to have known or should have known about the employer's policy or rule or practice that they're being charged with having violated. 2, the employer must have provided relevant and adequate training to the employee. 3, the rule or practice or expectation has to be substantively reasonable and consistently applied. 4, the employer has to have undertaken a fair and objective investigation. then five, finally, the employer has to have used progressive discipline. And then all of the statute also notes, that the employer, bears the burden of establishing that it's met the test. So in other words, the employer has to show that it has a good reason, for the discharge and has used a fair process before the worker can be let go for just cause. So that's in a nutshell. I've left out a little bit of the detail. Those are
Paul,
yes.
let me just interrupt for a second because we have to now go to the CLE information that Rory is going to share of the CLE code so people can fill out their form and get CLE credit at the end.
Great.
Rory.
Yes. Hello, everyone. So the CLE code, the first of two CLE codes for tonight's program is LER 321. That is L as in Larry, E as in everyone, and R as in Rory. 3, 2, 1. For those of you who joined a little bit later, if you have not, if you'd like CLE credit and you haven't put your email address in the chat, please do so and you will receive the forms. Back to the program. Thanks.
Now, Paul, we have a question about in terms of the just cause standard under the statute. The question is whether or not the just cause standard in this new statute is the same standard that would disqualify workers from unemployment insurance.
Yeah, good question. I don't believe it's the same. It's really, in several regards more demanding. It's more, the progressive discipline that's required and sort of the specific criteria I think are really more demanding than what's, the standard applied under UI. That said, that's sort of an example of where, there are administrative bodies are familiar with implying, a version of, assessment of whether a discharge was for cause. And while it's a somewhat different standard, it shows that, the kind of, familiar, that this isn't an unfamiliar concept and that, agencies are capable of administering it. So maybe I'll just turn now to the layoffs provision.
Well, before that, I just want to point out something for people who are practiced in labor and employment in collective bargaining situations, that the standard that's been codified in the statute is actually very similar to the 7 tests by Arbitrator Daughtry. And it's codified very, very specifically in the statute. And it's depending on how you read the statute, it could be 5 or 7 elements. And it's very clear in the statute. So you want to proceed with the Paul?
Yeah, thanks. I guess maybe something I'll just flag that, that I think interesting to note is that, another place where a cause standard exists and is commonly, applied in U.S. employment law are under executive compensation contracts, which, are typically, kind of golden parachute type severance packages are conditioned on a discharge not being for cause. And so it's just another example in that case, protecting very, very highly paid employees of firms. But yeah, I'll then now turn to the second ordinance, which is, the Layoffs Ordinance, which is, I think, in some ways simpler. So, and yeah, so the key provision says that fast food employers, as Councilmember Lander summarized, are permitted to lay off workers for economic reasons without having to show just cause. And then the law goes on to define the term bona fide economic reason, which is the standard for an economic layoff. And it has sort of two versions of it. One is the full or partial closing of operations, of the employer's operations, or 2, technological or organizational changes to the business. And in either case, that either the partial or complete closing or the technological organizational changes must have been in response to a reduction in the company's volume of production, sales, or profits. So that's the standard for an economic discharge. And then the statute, the law then lays out a few criteria that have to be satisfied to make that showing. First, like with just cause, the employer bears the burden of establishing it. Second, it must be supported by the employer's business records. Third, as Councilmember Lander flagged, once it's satisfied, the employer needs to use reverse seniority order for the discharge, and as noted, that's aimed at ensuring that economic discharges are not used to target individuals, which might allow them to be a means of sidestepping the law's just cause protections. And then finally, related to the if the employer implements an economic discharge and then rehires within 12 months, the employer is required to make good faith efforts to offer reinstatement to the employees who are discharged. So those are really that's an overview of the key provisions of the layoffs and the just cause provisions. I guess I'll pause now. I'm going to hand it off to Lisa to discuss the sort of procedures and remedies, unless there are questions Bill, that you'd like folks to ask at this point.
Well, we have one question asking about the exceptions that have been codified in terms of just cause, about egregious failure to perform duties or egregious misconduct. What is meant by those phrases, if you know, the egregious failure to perform and egregious misconduct?
No, I don't think there's any more specificity in the law, and it's more. I think it's likely that kind of the agencies implementing this and courts or arbitrators would look to those similar principles as they've developed in the arbitral case law that you referenced earlier, Bill.
It'd be more like about gross misconduct.
Yeah. Yes. So.
And the legislative intent here, which is that we knew we were hearing from people early on at kind of like are you going to make it be that there's like progressive discipline approaches even for the most outrageous activities? And what we tried to say is like you need to have a policy, and that policy is going to be different for different things. And if someone is late, maybe it's your policy that the first time they get a verbal warning, and the second time they get a written warning, and the third time, there's a disciplinary consequence. Write it down, tell everybody what it is, follow it fairly, you won't have any problems. And obviously, of course, there are certain kinds of activities that could get you fired on the first doing. Make clear to your employees what those are so that they'll know and don't do them. And obviously, promulgating those policies in advance would be the best way to make sure.
And then one other question on the statute. There's a mandatory notice requirement. Within 5 days, the employer is supposed to give the terminated employee with notice. What's the purpose of that, and what do you think the consequences would be for purposes of litigation?
Do you want? I mean, I believe that the purpose is just to require kind of a contemporaneous articulation of the real rationale for the discharge, rather than allowing after a discharge employer to kind of comb through employees' long history and try to come up with some alternative justification. So it's really an attempt to and also just in terms of fair process, the belief that an employee is entitled to know the reason why they're being let go, and so it allows the employer to do it shortly after the discharge, so that if there's some circumstance that requires immediate action, they can kind of complete the record, that paperwork shortly thereafter.
And what's the effective date of this legislation for the substantive provision?
Isn't it this summer? I should know the exact date. Let's see. Sorry.
July 4th.
July 4th. Okay.
180 days.
Okay.
With that, Councilmember Land, I know you have to leave. Do you want to give any final remarks before you leave?
I'm excited to hear. I apologize that I have to go. It's obviously a busy time right now. So I'll just respond. There was a study that we looked at. There was a survey of workers who responded to it, and we had some data there. And we certainly spent a lot of time talking to both the fast food companies themselves and to the franchise owners as well. So I think obviously there isn't a lot of data here on places where it's been legislated. Obviously, there are differences between companies that have it, but usually those have other things going on as well. So yeah, well, I guess the last thing I'll say is that, and Paul can talk more about this after I'm gone, but we were excited about the fact that there's an arbitration approach to adjudication here, and I think Paul will go into that more as well. But we want, the goal here is to encourage the right kinds of behaviors, not to spend all our time on what will happen after a worker believes that the law is violated, but to provide some different ways that make sure that they could get a remedy. And Paul can talk more about how that works and kind of why we think it's an exciting opportunity. But I'm grateful to be here. I'm going to follow up and find out, what ideas and questions came out that we should be paying attention to as we're working with Department of Consumer and Worker Protection, and they're promulgating the processes and standing it up. So thank you so much for the invitation.
Thank you very much. Have a good evening.
You too.
Our treasurer, Dan Dashman, has a question. So the call on Dan.
Hi, thank you. What I would like to ask is the council member was talking about when there's just one shot does it and you're out, and lists. I find that it's very difficult to deal when you have black and white lists of things, because invariably there's going to be situations that call for discretion. And just as we found with the courts with mandatory minimums, if the HR people don't have discretion to deal with it, and something being a union business agent and an opportunity to present that case, yeah, there are things that are going to get you fired real fast. Pulling a gun in the workplace usually is a good one, or starting a fire or something like that. But to try and make a list of it, I think is problematic. And I just wanted to wonder what your thoughts were about that.
Well, we'll talk a little bit more about that later. I think we're going to move now to procedures, which are very interesting in terms of the statute. And Lisa Griffith from Littler is going to now present on the procedures that are outlined in the statute. Lisa?
Yes. Hi, everybody. Thank you for having me here tonight. I do want to also just offer briefly some employer perspectives on the just cause discipline for fast food workers. I know that Paul's opinion is that a lot of the fast food industry did well in the pandemic, but contrary to that, the majority of them have suffered financially, and employers do find that this law coming on the heels of the pandemic really is a difficult financial burden on them. We also have in New York the at-will employment, which is the law of the land. There are many statutes in place to protect employees from unlawful discharges, including the anti-discrimination and retaliation laws. The labor law also provides for anti-retaliation law provisions, and the whistleblower laws. Employees are protected under federal, state, and local laws here in New York. And, we just feel that the just cause provisions are a reach and could be possibly a violative of the law. I do expect there will be challenges to the statute. The local laws are not supposed to be replacing the state law, and the state law and the Court of Appeals has routinely for decades affirmed the at-will nature of employment in New York. And that's not to say that, this industry doesn't respect their employees. And I think that giving them these employers are a bad name and suggesting that they don't treat their employees well is unfortunate, because a lot of our employers depend highly upon their employees, and treating them well is really the cornerstone of their relationship with their employees. So with that said, I don't know how much of the input of employers was put into the drafting of the statute and, how it impacts employers. But some of the things that are a concern to this industry are, I'll just go through. First of all, prohibiting the discharge of fast food employees' employment, reducing hours by 15% of their regular schedule or 15% of any weekly work schedule would be considered a discharge, invoking the statute. That's so minimal. 15% of a 25-hour work week is only 3.25 hours. And it doesn't allow for an employer to be able to justify ebbs and flows in business due to seasonal business needs and things like that. So you can have a violation if just one work week, the person's work schedule was reduced. And again, the burden is on the employer to establish that there was just cause for this. And many times it's difficult in this industry to be able to establish that through, the transient nature of the employees themselves. So it's not just that the employers are terminating employees for no good reason, but a lot of the employees are also coming and going. We also have concerns with the policies and all of the standards of conduct that employers must adopt. Of course, it's good policy to have standards, and it is good policy to have handbooks, and most of our employers do. And they do outline what is appropriate and inappropriate conduct in the workplace. But now requiring these policies, the adequate training, the fair and objective investigations into job performance and misconduct, all of this is a financial burden on the employer as well. It's not to say that providing a written explanation for reasons for the action is objectionable, but that is another layer that is not really required at all under at-will employment. These provisions eliminate business flexibility, increase operation costs, and interferes with the employer's relationship with its employees. If somebody is late one day, maybe we would have let that slide, but now employers are going to feel compelled to have to start disciplining with every small infraction so that it doesn't, so that it can fall within the progressive discipline procedures, especially when they're limited to a one-year look back. So that's, unfortunately going to impact the relationship between employers and employees. We also feel that employees whose jobs are terminated due to economic reasons and the selection of layoffs of the employees that must be in reverse seniority order is also problematic for these employers. You might have employees that are, fairly newer, but willing to work different shifts, that may be willing to want to make a career, maybe want to advance, so they're really proactive in their jobs, that an employer might want to choose to keep that person rather than someone who, just because they were here longer, who's not, all those things, they're still obligated to lay off the person who's newer and maybe providing a more tangential benefit to the employment workplace. There is also no distinction of job categories. I know Mr. Landers said that layoffs are within a relevant job category, but that's not in the statute. So as written right now, and unless we have other guidance, if you have a cook that you need to keep, but he's here has less seniority than the cashier, who do you have to lay off? Do you have to lay off the cook rather than the cashier? So these are things that we need to figure out as we go forward, but as written, they are problematic for employers. And then we have the issue of the employers that have to show that the closing or technological or reorganizational changes are in response to a reduction in volume or production, volume of production, sales, or profit. So that's basically reactionary. You can't actually take any measures to prevent having a negative impact on your business. You have to wait until that happens before you can then justify that you had to lay people off because there was already a decrease in the volume of sales, production, or profits. And that's unfortunate. It doesn't allow employers the opportunity to prevent those things from happening. With that said, there are three procedures available to employees if they are to bring a complaint. One is that they can bring a complaint to the Department of Consumer and Workplace Protection Office of Labor Policy and Standards. Two is they can bring a private cause of action. And three, effective on or after January 1st, 2022, they can bring an arbitration. So with regard to the administrative remedies before the Department of Consumer and Workplace Protections, and all of the three have a 2-year statute of limitations, by the way. The remedies available by the administrative agencies are the reinstatement or restoration of hours unless waived by employee, compensatory damages and other relief required to make the employee or former employee whole. And for each violation, the department shall order reinstatement or restoration of hours of the employee unless waived by the fast food employee. The department may, in addition, grant $500 per each violation in order directing compliance with the statute, rescission of any discipline that was issued, payment of back pay or any loss of pay or benefits resulting from the wrongful discharge, and any other equitable relief as may be appropriate. Now, the statute has not gone into effect yet. As we just mentioned, it's July 4th. But, you know, our experience with the agency and, you know, other such as the scheduling laws and everything have shown that, you know, the burden really is heavily on the employer to prove the just cause. And, you know, even where I have had employers that had documented, you know, proof that, you know, an employee was late to work and they were the reason why the schedule was different. A lot of it has been rejected by the agency. So I'm hoping that that's not going to be the same going forward, but I am a little concerned about how these complaints with the agency are going to go forward. There's also the option for judicial remedies in private causes of action. Again, the court could order reinstatement or restoration of hours of the fast food employee unless waived by that employee. Reasonable attorney's fees where a fast food employer is found to have unlawfully discharged the fast food employee. Compensatory, injunctive, and declaratory relief, including back pay for any loss of pay or benefits, and other compensatory damages and other relief required to make the employee whole. And finally, effective on or after January 1st, 2022, arbitration procedures and remedies will be available as well. Any employee or organization representing persons alleging a violation of the subchapter by a fast food employer may bring an arbitration proceeding. The department can create a rule permitting class action arbitration. Arbitration proceedings must be brought within the 2-year statute of limitations. And the remedies for violating the just cause provision include the employer required to pay the reasonable attorney's fees and costs of the employee, require the employer to reinstate or restore the hours of employee unless waived, require the employer to pay the city for the cost of the arbitration proceeding, and award all other appropriate equitable relief, which may include back pay, rescission of discipline, and other compensatory damages. So as you can see, going the route of the arbitration can be extremely costly to employers, having to not only pay the employees their attorney's fees and costs, but also the cost of the arbitration itself, as well as other fines and compensatory damages. So, you know, I don't know if anyone has any questions about, you know, the section right now. I think that's really what the procedures as they're laid out. We haven't had any cases yet. Obviously, it hasn't been instituted yet, but we will see how it does get played out over the next year.
So we have a question for Lisa from John Berenbaum. What challenges to the law do you anticipate?
Well, I do challenge. Well, I see two. One is that only the New York State Legislature can retract at-will employment and enact just cause legislation. This is based on the fact that there's several Court of Appeals decisions going back decades upholding the at-will doctrine in New York. And in addition to that, the local legislature is not permitted to undo state law by legislation. So there's a big question mark whether or not this just cause provision will be upheld. I do anticipate that there will be some lawsuits filed. And then the second possibility is that the proposed just cause legislation could violate the contracts clause of the United States Constitution. The employer and employee relationship that has been established already as an at-will employment relationship will be impacted by this new change in that relationship by the just cause legislation. So that's another grounds that we foresee someone can challenge the statute.
You know, although I think it was clear, I just want to underline or underscore that the definition of wrongful discharge includes either lacking of just cause or lacking a bona fide economic reason. So both of them are defined as being a form of wrongful discharge. So the three procedures that Lisa just described are applicable both to classic just cause kind of issues as well as to layoffs that could be litigated then in three different forums. one of the things that that Lisa did not mention, which I want to just also mention, is that particularly for the arbitrators, is that the statute has a procedure for selection of arbitrators involving creating a panel that would include both employee and employer representatives, coming up with a list of people to be on the panel, et cetera. So for those of you who are arbitrators, you may want to take a look at that. We have a question from Eric Brooks, and the question is, will employees and their representatives be able to require production of records through subpoena or other means? I'm not sure whether that's reference to the administrative process or the arbitration process or the litigation process. I assume litigation would be discovery would be applicable, but I guess in the administrative process, will employees be able to require production of records through subpoenas?
My experience with the administrative process is that the agency will serve a demand for documents that is usually pretty lengthy, requiring the employer to produce documentation supporting their justifications.
In the context of a plenary action, the discovery would be applicable. So it would be a completely different scenario. You're talking about an administrative investigation.
Correct. Right. Yes.
Bill, Lisa, Bill, on the earlier question about the authority for the law, could I just?
Sure. Please.
So, we believe that there's ample authority under state home rule law for the legislation. There is a relevant precedent. The city has already regulated discharges in certain circumstances. It has several worker retention laws applicable, I believe, to hotels, I think grocery stores, and property services, which require limit employers' ability to discharge workers. And I think those have been upheld under home rule law, as have a wide range of other local labor regulations. One of the few areas where there is preemption is around minimum wage regulation, where there is a Court of Appeals ruling saying that the city is preempted from regulating. Some have also raised the question of whether the NLRA would preempt, just cause legislation, and the Third Circuit has addressed that and rejected the argument that the NLRA preempts. That's upholding the Virgin Islands just cause law, and that case has been cited favorably by the First Circuit. I don't believe the Second Circuit's addressed the issue yet.
Yeah, on the federal preemption question, the case that Paul just referenced is called St. Thomas St. John Hotel Tourism and Association, 218 F3rd 232, Third Circuit in 2000. I see a question from Cliff Shallett. Cliff, do you want to ask it through chat, or you want to do it?
That's okay. I can ask. It's Cliff Shayette, but that's close enough. I know I find the entire discussion fascinating, and I appreciate the law. But the question that I have, and probably it's beyond what we're talking about in terms of procedure. Back in the day, I used to do a lot of work in Puerto Rico, and Puerto Rico passed labor laws that essentially were designed to do away with the need for unions. This particular law seems to be going in that direction. If you are replacing the just cause provisions in contracts and the arbitration provisions in contracts, why do employees need unions? Just an open question.
Yeah, and we have a similar question from Mark Kagan, who said something similar, which is obviously unions can negotiate an end to at will. Is there a distinction between a union doing that and the city of New York?
I think this is a protection for the vast majority of non-union workers. It's a minimum labor standard that the state and increasingly the city has regulated to set minimum fair labor standards, and there are protection precedents for regulating layoffs, chiefly in these displaced worker laws, and it's really, I think, a different. It doesn't dispense with the important role that unions play, and many of us support labor law, the call for labor law reform and the PRO Act to rebalance our labor organizing landscape. But I think regulating fair, fair, unfair discharges is really just a different creature.
Well, it's not just, discharges. In New York City, New York State, we're expanding the benefits provided to employees, which I have absolutely no objection to. But it seems to be that the law is displacing the need for a contract. And by the way, Evan, that is a beautiful little puppy.
Our view is these all regulated minimum labor standards set the floor above which, workers who have a union, bargain. And that's, there's increasing recognition from economists and really even the business community that, widening inequality is impoverishing the American middle and working class and really hurting our economy, and that we need stronger minimum standards to improve conditions in our labor markets. And we think these are one of them. And if you heard the stories from the hearing, it's really all a racial justice issue too. The impacts of unfair firings are actually really fall disproportionately hard on Black and Latinx workers. They face longer periods of unemployment when they lose their jobs. They have less household and family wealth to fall back on. And the fact that you can be fired without notice, there's no even requirement for severance pay in the U.S. is really unusual. And I think this legislation is attempting to get at that.
And we should mention that in terms of the tension that exists between protective laws and labor organizing, this is an old debate. It goes back to Samuel Gompers, who opposed this kind of legislation for exactly that argument. And we've seen that through anti-discrimination laws and a whole host of anti-retaliation provisions, that there's generally been movement on the federal, state, and local level to expand these kinds of protections. So I don't think that there's really much difference in terms of the that tension, but it's certainly something that has been debated for over a century on the labor side. So does anyone have any further questions for the speakers, or can I?
If I could, Bill,
Go ahead.
It's Dan.
Hey, Dan.
I just wanted to make one comment. My dear friend Cliff Cheyette threw the hand grenade, and I thought I'd catch it and toss it back a little bit. There are so many issues that labor unions need to be able to address, that when we take something like just cause off of the table and allow us to go back towards things like defined benefit plans and pensions that are defined benefits and so many other things, it just allows us to have the freedom to go after issues that we have not been able to attack for decades. That was my comment. Tossed it back to you, Cliff.
So in our audience, we have some very distinguished management attorneys, some very distinguished union and plaintiff side attorneys, and some distinguished arbitrators. So I think that it would be interesting to hear from those different perspectives about how you see it from your vantage point about this new statute and what it may mean for your practice and for the employees and employers.
Boy, that one didn't generate much response.
All right. So, well, in terms of the question about the interface between this statute and employment discrimination laws, I'm just curious for Lisa and Paul, what does it mean in terms of employment discrimination cases with the statute now requiring a notice of the reason for the termination?
Good question. I mean, I think it will, would be helpful in employment discrimination cases, because it would already be, the employer would already have had to articulate the notice, the reason for the discharge. I mean, I think the main way we think it relates is there's a lot of unfair treatment that may have a racial component, but it is often really, it's very hard to litigate or prove, under the discrimination laws, whether it's race discrimination or gender discrimination or others. And so we think, requiring just, for all employees, a fair process with a good reason and fair notice before you're fired really helps protect workers against a lot of unfair treatment, much of which may have a racial or gender component, but that really can't really be enforced under the anti-discrimination laws.
What would how would the notice play out in terms of dealing with the question of rebutting an employer's non-discriminatory reason in an employment discrimination case?
So I guess, it would obviously be litigated, that would be I suppose the employer would be limited to the initial proffered reason, and then I guess the same burden of proof that applies under the burden shifting regime under the employment discrimination laws would apply for that claim. There isn't the same burden shifting system under the new just cause law for the just cause claim.
So in response to my inquiry to an arbitrator, Erica Tanner suggests that from an arbitrator's perspective, there isn't too much of a change in how we would handle the cases. I guess the question is whether or not the statutory mandate and the statutory definition of just cause, how that would interface from an arbitrator's perspective on the case law that's been developed over decades with regard to the definition of just cause under a collective bargaining agreement. I feel like I'm a law school professor asking. Come on, didn't you do your homework? No.
I'm not an arbitrator, but it seems, as you were noting, it seems fairly similar. So I would think, as a practical matter, whatever pool of arbitrators they draw on to enforce this regime would draw on that body of experience and precedent that, because it does seem like the standards are fairly similar.
Now, one of the things we have not mentioned is that there's going to be regulations issued by the Department of Consumer and Workplace Protections relating to both aspects of that statute. So some of the questions that are currently, that Lisa raised, may be resolved through those regulations and filling up some of the holes that exist in the statute.
Bill, this is Rory. At this point, I have to read the other CLE code. So everyone who's looking for CLE credit, the second CLE code for tonight's program is EBG 323. That's E as in elephant, B as in baby, and G as giraffe. And the number 3, number 2, and the number 3. I have a 2-year-old, which is why those things come to mind.
Now, Rory, you have a question?
Yeah, I placed a question in the chat. Has there been? I realize that this would be a hard study for someone to conduct because there aren't a lot of large jurisdictions. No offense to, I know there's at least one Montanan here, but there aren't a lot of large jurisdictions that have just cause laws. But have there been studies on the effects of the economic benefits and detriments of the law? I know as when I advocate on behalf of the union, whenever I'm advocating for something, to say, yeah, this might cost you more, but you're going to have better retention, you're going to have less turnover, you're going to have better outcomes I work for a nursing union, so I'll say on the floor. Has there been any studies weighing those kinds of benefits, like the kinds of things that I just talked about in the fast food world versus the detriments, the rising prices, people aren't going to open up the shops, those kinds of things, and understanding they're hard to gauge.
There is a body of research I know that looked at, it was not full just cause, but looked at the state wrongful termination laws that developed decades ago, which have been weakened in many cases. And I think others, I could point you towards other folks who, or some of my colleague Irene Tung is familiar, I think, with that literature more. I recall one of the benefits that I think they identified was employers were more likely to invest in training, which would kind of make sense if it's becomes more difficult to fire workers, that's sort of a rational employer response. I think another thing that economists believe, and maybe some of that experience shows, that unless the standards apply equally to temp and staffing workers, there'd be, a likely employer response to try to, shift jobs to temp and staffing. So, our view is with these types of laws, it's important that that they apply equally to staffing or temp workers, that are placed at a host employer.
Well, there's also a concern about the move to automation as well.
It could potentially be that, although it's really interesting. I don't know if it's not in this context, but in the $15 minimum wage, I don't know if you saw, there was a study just recently about the movement to the self-serve kiosks, and the pattern seems, there's as much movement in Texas with the $7.25 minimum wage as there is in California and New York with the $15 minimum wages. So it's, at least in that context, something that clearly increases employer operating costs a lot. There was no evidence that it was a big factor in the pace of the uptake of that technology.
Well, I think the pandemic is also going to impact the automation piece of it, because employers have seen ways of being able to provide services to their customers in a safer fashion, by not utilizing actual human beings, but being able to utilize, the automation of different machinery and things like that.
Yeah, no, absolutely. I mean, there's automation in fast food is huge. There's huge amounts of it, but it's also, in the last decades, it's gone hand in hand with continued very strong job growth, partly because the segment, I think, of the restaurant industry is continuing to grow a lot. So there's all touchscreen technology and automated ovens and all sorts of technology, but the headcount of fast food workers has continued to boom, as the sector. And I think during the pandemic, like takeout has really boomed, and fast food is a big player in food delivery. So, I think it's independent restaurants that have really suffered and are being squeezed out, especially during the pandemic.
I disagree.
So Lisa, the statute establishes clear rules that have to be complied with by fast food employers in terms of discipline. How do you foresee this new statute will affect the way in which employers focus on their actual handling of progressive discipline kind of issues? Do you think it's going to enhance the degree of training of managers and enhance the work done on handbooks and other kinds of work relating to progressive discipline?
Yes, we're already training our employers, the management staff on progressive discipline procedures, putting in place policies that are compliant with the statute, obviously waiting for the regulations to come out to be able to finalize them. But I do foresee that a lot more time and money will be spent on that. Although, like I did mention, a lot of employers already do have policies and procedures in place. But on top of that, I think it's also going to result in heightened scrutiny of employees at some point, because where you might have let things slide, like I mentioned before, you're the employer's compelled to now document everything and make sure that they're meeting this timelines of, wow, it's a year. We've got to look back and make sure that we have taken care of these issues now. And if the employee really hasn't progressed, we're really not going to be able to spend any more time on it, or else we're going to, this conduct's going to drop off. And that actually, is similar to the Section 75 civil service law rights. They have 18 months, which you can bring misconduct charge against someone. And employers are always looking back to make sure that, I don't want to lose that statute of limitations issue. So that's definitely going to be something that will be followed by our employers.
Just underscore, you mentioned the year's time. That's applicable to what constitutes progressive discipline, correct? So progressive is only what's happened in the past year can be used with regard to disciplining an employee.
That's right.
So how do you think that's going to play out for a fast food restaurant in terms of being able to keep track of that, in terms of documentation, in terms of training, in terms of giving policies out to each employee to get signed?
Yeah, I think a lot more time is going to be spent on employees' disciplinary procedures. So they will have to establish this progressive discipline. So, you don't know what's going to be significant down the road. So I would assume that everything that an employer takes objection to is going to be documented. And then, you know, we'll look back after a few months to see, you know, how are we doing? We've given them a refresher on the policy. It continued to happen. You know, now this issue came up, we gave direction on that policy and it continued to happen. And so a lot more focus will be on those issues to make sure that they don't drop off within that 1 year look back.
Do you think it's going to result in greater uniformity among fast food establishments by having this law in place with these requirements?
Among different establishments? Are you saying like within the industry itself, that now that everyone has the same procedures? I guess it could, yeah, result in uniformity amongst the industry.
And so that would then for employees then would be getting the same kind of treatment wherever they worked in terms of following this particular statute.
Well, I thought it was something that Mr. Lander said that was interesting, which is that, you know, you have to design your policies based on what is important to you and what you see as something that would be an egregious violation versus, you know, something that we can tolerate latenesses, you know, 2 or 3 times, but not 4, something like that. So you might have differences amongst the restaurants.
Actually, speaking to that point, and one of the questioners raised it, I don't read the statute as necessarily requiring that egregious violations or be defined ahead of time. I think it's referenced only really. I think there's only one provision in the statute that references that, and so I actually think that employers have some flexibility about what counts, what rises to that level, because there probably are a wide range of types of egregiously inappropriate conduct that could so qualify.
Right, then in the hands of the arbitrator or the administrative agency, wasn't there, who's not familiar with the employer's policies, to make a determination what should have been egregious. So, you have to it's a balancing act. What is more important, that you have it in writing that, if you're going to scream at a customer, that's egregious, or leave it up to an arbitrator who maybe months later is going to say, oh, it wasn't such a big deal, and they weren't present at the time.
Yeah.
We have a question from Lisa Byrne, whether NELP or anyone else compile just cause statutes that have been enacted. I'm aware of Montana. Where else?
So I think I chatted this recent Roosevelt Institute report by University of Michigan law professor Kate Andreas and former Columbia law professor Alex Hertel Fernandez, and that has a good overview of. I don't know if it has. In the U.S. it really is Montana, Virgin Islands, Puerto Rico, these new Philly and New York City laws. I think, and then there's what exists. The kind of it's really a different animal. The court created limits on on fair discharge, but I think those are really the existing. Outside of public sector employees, many civil service laws have a just cause standard, but I think it's really just Montana, Puerto Rico, Virgin Islands, the Philly and New York laws, and then they have a good overview of the international context. But there's a lot of interest in these policies, and I think we'll see more proposals in other states and cities very soon.
And in the materials that are in the link that we posted before, there's an article that lays out a lot of the history involving the just cause statutes. And going back to Lisa's point about the standard for at-will employment in New York, at-will employment is an element of the common law. And the New York Court of Appeals has been very resistant to making any exceptions to that common law rule. There have been a couple, but it's very, very rare. In other states, as Paul just mentioned, there have been cases which have recognized exceptions to the at-will doctrine as a matter of judicial interpretation of the common law. And that's case law that could be relevant in terms of interpreting this statute, in terms of how the courts have applied that exception to at-will. So does anyone have any questions, or should I proceed with my examination of the witnesses? Cliff.
a question. I've been listening to this. I'm trying to figure out whether this law would have come into play if the minimum wage hadn't been raised to $15, and this now turned a summer job, a college job, a student job into what may be a somewhat of a career.
I mean, I think workers have been pushing for fair job security and protection against unfair discharges, for years, regardless of how much they're paid, but you're right. I mean, it probably, it's quite possible the fast food industry, that maybe I don't know, Lisa, if your clients believe the turnover is going down now that the minimum wage has gone up and there's paid sick days and the like. It may be workers are more invested in these jobs because these minimum standards have been extended to them. It's interesting, but there's definitely a need. We think there's workers, and as Councilmember Lander suggested, even white information economy workers like journalists are fighting for just cause. At the same time that that parking lot attendants in Philly and fast food workers are. So we believe workers at every level need these types of protections. But it is a good question about how the fast food industry may be affected by these minimum standards.
Lisa, do you have any response to that question?
I think that's a good perspective. That probably is where this is a driving force. And you do see a lot of if you go into fast food restaurants, you do see a lot of not just college age kids, but more adults who presumably have families working these jobs now. And I think that you're right that there probably are making this a career, or at least something that's stable for a long, hopefully a long period of time for them.
An interesting place to look would be upstate, because New York now has the $15 minimum wage applies to everyone. But upstate, it's only fast food. Fast food still has a minimum wage that's like 14 and change, and we'll go to 15, I think, in July. But the minimum wage for other industries is just $12.50. So it'd be interesting to see, what that is doing to fast food jobs upstate. I had heard anecdotally that the home care industry thought it was putting pressure on them to raise pay. That fast food jobs were paying more than home care jobs, and by some measures are not as demanding as home care is a very demanding type of work, as is fast food. But anyway, it would be interesting to look at that.
It has certainly been an impact in the nursing home industry upstate, where people can go to get a job for $15 an hour at Burger King or McDonald's, and here they are taking care of people who are ill for a heck of a lot less than that.
Yeah, which is why we need to raise the state minimum wage to 15 statewide. And I think there's legislation. I think there's legislation in Albany that would do that, and we're strongly supportive of that.
So Evan has a data question that I hope we can answer for him, which is how many employers in New York City have 30 or more locations and would be covered by this new law?
That somebody knows that. I don't know offhand, but I think it's the big chains, and I think the law applies both to the chains that operate all their locations, like which some of them do, like Shake Shack, or I think Chipotle, or I don't know, some of the others, and then the ones that franchise. I think it treats franchisees as as still part of that head count. So I think all the name brand fast food companies you'd think of, and then some of the the coffee bar chains and others, some of the big companies that are captured.
Right.
Yeah, sorry, Lisa, you must know this offhand. Sorry.
I don't have the data, but I agree with what you just said, that I think it does cover all the franchisees as well. So even if you own 2 McDonald's in the city, obviously you're still going to be covered because the franchisor has probably hundreds of McDonald's in the city.
And Paul, I know you follow this a lot closer than most in terms of this public policy issue of just cause. Do you know whether there's any movement in Albany for modifying the at-will doctrine through a just cause statute?
I don't believe so yet, but there actually, as Councilmember Lander mentioned, there actually is a state level campaign in Illinois for a state just cause law that it's being anchored by a group of worker centers that they are the Raise the Floor Alliance. So I think we'll see more state and city level proposals of this type, but I don't think there's any in Albany yet.
Does anyone have any additional questions in the audience?
We're gonna get down?
So with that, I wonder whether Paul and Lisa want to sum up?
Sure. I mean, I don't know. Lisa, do you?
I would just like to say, thank you again, everyone, for being here tonight. Hopefully we can do this in person in the future. We look forward to the regulations. I think a lot of the statute and the concern that the employers have right now could possibly be addressed by these regulations. So I hope they come out sooner rather than later so that we can get into compliance before the law is in effect, July 4th. Obviously, I just want to reiterate that our employers, at least that, we work with, and I think that goes for a lot of them, see the value in their employees and do have policies and procedures in place already to make sure that they are treated fairly. And there are laws that do apply to help employees if they feel that they haven't been treated fairly, including the discrimination and retaliation laws. So we just feel that this has been an overreach and is unnecessary. We do understand where it's coming from, but at the same time, and we do respect the employees and their rights, but we do feel that it is an overreach. But that's our perspective, and I do appreciate Paul's and Councilmember Lander's perspectives as well. Thank you.
Great. Well, thank you, Lisa. It's been great being on the panel with you, and thanks, Bill, for the opportunity. And yeah, we're as very supportive of this legislation. We think it really, in many ways, codifies sort of the practices that responsible employers, by and large, already use in terms of giving employees fair notice, good reasons, a chance to address performance problems, and before they lose the paycheck that they and their families depend on. And the political polling shows that just cause is actually it's even more popular than the $15 minimum wage. It consistently polls in sort of the high 70% range. Commands majority of even Republican voters support just cause protection. So it's really something where the workers, the public really think some minimum fair rules before you're fired are appropriate. And I think this is a conversation that has really died out at the national level, and we're really delighted to see New York playing a role in reinvigorating it. And we look forward to the agency's work to implement this important law and to continuing this conversation.
Well, thank you both, Lisa and Paul. I'll turn over the rest of the session to Rory to give an update about upcoming events for the chapter. Rory?
Yes, so good night, everyone. Thank you. We have an upcoming event in April for our lessons learned for collective bargaining through the pandemic. And we haven't pinned down a date yet, but we're looking at the week of April 20th. And following that, our final event for the year will be in May or early June. And that one will be on workplace investigations, which is a topic that always draws a lot of people who aren't just lawyers, but a lot of our clients and other people who deal more with that on the ground level. So we're looking forward to that. We're hoping to see a lot of you again then. Looking forward to next year as well, where we anticipate having some in-person events and hopefully being able to gather together, and encouraging you all, as always, to up your membership or re-up your membership to your local chapter, support your local chapter. We have some exciting things going on and we appreciate it, and we're happy to see everyone. So good night.
Good night.